to do the closing remarks. How do you introduce a legend like Ralph? I call him Mr. Legal Writing. Has somebody already called him that? I don't know, but he's Mr. Legal Writing. He literally co-wrote the book, the source book on legal writing programs, the original version. He's been teaching for 51 years. There's a great YouTube video about his 50 years online, so it's 51 now, if I read correctly. He's been the director of the Chicago Kent Legal Writing Program. He's built it and built it into a model. He's led every possible legal writing organization we have, the ALS, the LWI, the Allwood. I'm sure there's many that I've missed, and also served as an appellate consultant. So let's give a big warm welcome.
Well, much of what I was going to say has been taken away by great speakers, naturally, especially Terry. Yeah, I'm supposed to talk about the past, the present, and the future. I hope this isn't like the commercial where the 10-year-old is telling the 7-year-old that you don't know how it was. You can record 5 shows at once. I actually was going to retitle it into the ugly, bad, and good, rather than the other way around. When it started, it was not too hot. It's actually now 52 and a half. Left out. Look, I have a unique experience. I've been a student, of course. I've been a legal writing teacher. I've directed a program. I've been a dean. I've been an associate dean. I've been a doctrinal teacher most of my life. I've been very active in all the associations, both ours and, of course, at the larger level of American Bar and global Chicago Bar. My overall conclusion is something that I think was epitomized by what Terry showed on the screen. Who would I want to have a drink with for 2 hours and talk about legal education? I told you all those roles. I've done it with deans. I've done it with other professors. Those are not happy experiences. What are the doctrinal teachers want to talk about? You want to talk about their scholarship and their leaves of absences and their research budgets and the rankings of law schools, and maybe they can work their way up to a more elite school. And the deans are talking about how they can also get up in the rankings and maybe cook the books a little bit on some of their placement data to attract a few more students. What do we talk about? We talk about teaching methods and learning methods and problems we can share with one another and good ideas or other things we can do. It is such a pleasure to talk about students and to care about students. That's what we do. So that's been my pleasure all my life. That has really kept me going. Let me tell you how I was a student. My legal writing course actually was taught by a graduate of this school. Don't take it out of him when you hear what he did. We had 3 assignments, a closed memo, an open memo, and a brief. I got them back with some red marks on them. They were circles around spelling. I spelled judgment wrong 9 times. I got 9 points taken off. And it was only spelled wrong because it had an E in the middle, which I thought was in the dictionary. It was pretty clear. We never had a book. We did not have any samples of what a memo was supposed to look like. We had about a 2-hour lecture on that. This was a graduate student at the time. He had graduated from here. He was at the University of Illinois as a graduate student, along with 2 others. And they were the ones who were teaching legal writing. They were nice people, but really it was, you learned on your own. And that's basically what legal education in legal writing was about those times. I taught for a year at the University of Michigan, their problems and research course. There they at least had a supply of old problems and we had something to draw from. But there still were no books. to speak of. And when I came to Kent, Chicago, Kent, my first teaching assignment, I taught property, agency, day and night, and legal writing to a class of 75. And the second semester, there was a class in property and damages, and a class in legal writing to 65. And that was day and night. I was up till 2 o'clock in the morning every night, staying ahead of students, and also, of course, trying to do some work on those legal writing papers and assignments. Because I gave 3 assignments, even though that course was only worth 2 hours, and that was the only course in the curriculum. I was the first one ever teaching it there. They had not had such a course before. And who taught at the other schools? At that time, I looked into it. There were primarily people like me at that time, doctrinal teachers, who were also teaching legal writing either as part of their courses or separately. Somebody mentioned it earlier. I remember who had an assignment to teach a section of legal writing, right? That was sort of the movie trials of the time. And you didn't do it forever. You rotated like other people teaching. Or there were librarians. There were separate courses. We had a separate course in legal research. And the librarians would teach legal writing along with it. They would give assignments and grade them. Or they were law students, 3Ls. They were graduate students like the one I had. Or they were like in the Michigan program that I was in, straight out of law school. You know, just graduated, and there I was teaching second-year students in Michigan, not first. So when I had to create this course at Chicago, Kent, I looked around for books. There weren't any books. I did research subsequently. In the period from 1960 to 1980, there were a total of 33 books that were on the subject of legal writing. Only 3 of them could have possibly been used as textbooks in law school. George Gopin's book, Judge Ray's book. Marge Rombauer had a book, but I didn't even know about it because it was self-published. It wasn't a vendor's book. It wasn't at West. It wasn't at Foundation. She had to publish it herself. So I adopted Henry Weoffen's book, which was a great little book and stuff. It's still around. It's a wonderful book, not for students. I mean, really, it's a glorious book for learning how to legal writing style. But it didn't work as a book, as a textbook. Okay, law review articles. I started looking for law review articles. After all, there must be law review articles on how to teach this course, right? Again, from 60 to 80, there were a total of 75 law reviews, that's 20 years, that touched on legal writing. And several of them were like the one by Will Pedrick at Arizona. It said, we shouldn't be teaching legal writing in law school. People should learn this in high school and in college. And we can't do that. And the other one was by somebody named Griffin, I think it was, teaching legal writing for no cost, University of Kentucky. That was their program. I don't even know what it was. I saw no cost. I knew mine was going to be law school. How many law reviews do we have now? Just on the subject, and I'm not talking about the second draft and perspectives and those things. I'm talking about law review articles like the ones that Terry put up on the screen. I looked at the index to legal periodicals. I haven't done that in a long time. Before this, 2011, there were 167 just on this subject of the things that she was putting on the screen. And amazing. And of course, that's in addition to the second draft and perspectives and the ALS newsletter and Scribe's Journal and the Legal Writing Journal and the Allwood Journal. And what a field. Incredible. The ALS. I went to the ALS meetings. I thought, okay, I'll meet some people there. They must know what they're doing. I met a lot of nice librarians, because that was the first directory that showed what people taught by subject matter. Had a big long list of people. some of them had been teaching apparently liberal writing for 10 or 15 years. That's where they were listed. No, they weren't. They were librarians, or they were the doctrinal teachers that I mentioned. They were teaching those courses. And if there were a few others that were teaching liberal writing, they weren't there the next year. They didn't stay in the field. So we were pretty much on our own. An amazing event happened first in 1980. The ALS finally agreed to a workshop, which was held in Louisville on the subject of liberal writing. We had 45 people there, including Mary, and including Marjorie on Bob. And it was a great program. And 5 years later, Mary was the chair of the section, and she got them to put on another workshop. Now, that was quite an achievement. The ALS has workshops for various subjects, but they have a rule that you can't do them very often, except for clinics. And the clinics are a whole different subject. I'll talk about that later. She got them to do another workshop 5 years apart. And that one had 85 people from 60 schools. In 1984, Puget Sound got three giants from Puget Sound. Chris Rideout had gotten a grant, and they had spent all the money. So he talked his dean into putting on a program called Teaching Liberal Writing. And 100 people showed up for that one, including Mary. And 2 years later, they incorporated it as the Liberal Writing Institute. And of course, the rest of that is history. Every 2 years, wonderful. Last year, it was 600 people. What was it last year? In Florida. And along with it, of course, there were the regional conferences. This conference, the one-day conference. There were 17, I think it's 17 this week. Is that right? And they averaged about 40 or 50 people each. You do math. Amazing. Compare that. I teach torts. I've taught constitutional law. I've taught 15 other subjects. Do they have conferences? There are about 2 conferences on torts. DePaul has one annually because of a grant that they got from on a loan. What do they talk about? They don't talk about teaching torts. They talk about substantive, the scholarship that they've done about this case or that case, their own theories about things. One of my colleagues talks about corrective justice, another one talks about law and economics. They don't talk about teaching torts. It's not on the subject. The teaching methods section of the ALS. I used to go to those. I thought, at least that would help me learn how to be a better teacher. 30 people would show, 20 people would show. Until a strange thing happened about 6, 7, 8 years ago. Liberal writing people started taking over that section. We had 200 people there. Sophie Sparrow did this amazing job on assessment. She had an overflow crowd. The source book, 1996, that came out. Why did we have to do a source book? There were so many schools that had no programs at all. They were constantly reinventing the wheel. Again, they were assigning it to someone and saying, teach it. And all they could do was possibly call somebody if they knew. There was no source of calling people or getting a hold of people until the 94 conference of the LWI, when we at Chicago Kent created the listserv. Now, there's been some comment about emails. The kind of emails that are on the listserv are not the kind that were criticized today. There's very seldom that somebody accidentally said something that talks about some individual. What do we send? We send the congratulation ones, of course. But we also send ideas and sharing. Does anybody have a syllabus we can use? Does anybody have a problem involving this? What do you do with blind students or students who can't hear? And we get instantaneous responses from people all over the country who are willing to share their work. It's just amazing. The standards, there's a few of us that started to work with the ABA to try to do some of the standards. We did get 302, which is underrated. It's a standard that says that law school must teach legal analysis, legal reasoning, oral and written communication, and legal research. The things that we do. And yes, we do those in doctrinal courses too, but the one place where we do them best is in the legal writing programs. So we got that. We also got legal writing people for a while, if they were full-time, were counted as 7/10 of a legal day. And don't think that wasn't important, because that enabled lots of schools to satisfy the student-faculty ratio that they weren't able to do before. And then there's 405C and D. We do surveys. We've done a lot of surveys. Jill did the first, and then we continue. Let me just do two for comparison. In 1989, the student-faculty ratio was found to be 60-1. Salaries average $27,000 for full-time legal writing teachers. Only 10 people were on tenure or tenure track. It's 1989. Most of the people were on short-term contracts, and most of those were capped. They had to teach for 2 years or 3 years. And when they finally learned how to do it, they had to go. Nobody else had to. The Xerox operator, they could stay every year. The janitors, they weren't kicked out, right? Only the legal writing people. In 2012, somewhere, you'll excuse me, he's out of order. Where to survey? The majority still are on short-term contracts, but there are only 9 programs where they are capped. That was for something like 170 schools that reported. So that's a major change. 71 reported that they had 405C status, that is 5-year contracts, presumptively renewable. Not tenured, but pretty close. 40 reported they were tenured in 2012. And the average salary was $75,225, and the student-faculty ratio, 39.6. It's a lot different than that 70. Today, the dean started off today talking about the crisis that we have in law school. There's no doubt that it is. Applications were down 13% this year. They're going to drop even more next year. Schools are cutting back. This is a crisis. It can have a very bad effect on the learning people. There's also one other factor that may also impact. The ABA Standards Review Committee is meeting. In fact, they will be meeting in January to vote on one of 2 possible revisions to 405. And one of the things that they will be doing, recommending, is to abolish tenure as a requirement for any teacher, not just the writing teachers. The other one will say all teachers must be at least hired on a 405 kind of basis, 7 years of probation, and then renewable 5-year contracts. That one's fine. And the other one will just say academic freedom will be guaranteed and a role in government. Those are the 2 that are on the table. But those 2 were drafted before this rising crisis. And I have a hunch that some people at that committee meeting will try to water it down more. If the latter of the 2 pass anyway, if there is no tenure, if there is no 405 DLC guarantee, how are they going to attract and keep able teachers? The only way you can do that is with money. And of course, deans have to share the money with the doctrinal teachers that they want. Salaries are bound to be affected by that. What else will be affected by this crisis? And teaching loads. They have to do something about the teaching loads. The average doctrinal teacher now in my school, we teach 9 to 10 hours now. I teach 3 courses a year rather than 3 a semester. They're not going to increase those too much, but I have a hunch they're going to start picking on what they regard as the weaker ones. And the weaker running people, therefore, might have those things increased again. And of course, there may be jobs eliminated as well in that. So, what do we do in response? One of the things three things at least, have been suggested by people. One are the global programs. We already have had, for 15 years now, a graduate program for foreign lawyers. We now have something like 150 Chinese students in residence at the law school. And we also have faculty who teach there in China in 2-week periods. We have a program with Thailand. We have a program with Poland. We have a program with Ukraine. Frankly, it's the financial survival of the school right now. We graduate 150 graduate students every year. It's like the United Nations, and it's great. We have special classes in English for those students, and they do well. Some of them actually take the JD as opposed to the LLM. Those are a little bit more difficult. They're smart, but the language difficulty does affect their abilities to succeed. The other ones that have been proposed and some schools have adopted are so-called capstone programs, and I'll talk about that in a minute. And the other is an incubator program where recent graduates, the law school will set up offices for them in return for services. So in our case, our incubator program right now, they will get offices, very nice offices, in the 6th floor of our building, in return for doing work with the clinic. We have a very large legal clinic, all different kinds of lawyers. So they will put in X hours as associates, in effect, with this law firm in place. It would be better to make one of those programs help the law school in other ways, too. Why does it have to be the clinic only? Why not mentors for the students, or legal writing teachers, or something upper classes like drafting, or the other ones that have been mentioned today? So that's something to think about, and something that perhaps you can do things about. My reason for talking about this is it's something that you can push, that you can be a leader in. And the same is true for the capstone program. The capstone is a semester or a year of practice-ready training, of the skills training that we do best. And again, rather than wait for someone else to move it, it would be better if the legal writing people themselves would formulate an idea and a plan. To have a semester at least of advanced writing, legal drafting, negotiations, mediation, practice court, externships, all the kind of things that would tend to make people practice ready. And again, if we sit back and wait for somebody else to come up with a capstone program, it's not going to be that. So I would urge you to go back and try to push for things like that. So that's it.